A very good morning to all my dear students. Today we are going to start with a new topic, and the said topic is plaint. As you all are aware that in my last lecture we had discussed about the concept of pleadings, wherein I had apprised you that the pleadings has been defined under Order 6, Rule 1, CPC, wherein pleadings defined as or includes plaint or written statement. Furthermore, it also talks about or lays down the fundamental rules of pleadings. And the fundamental rules of pleadings are laid down under Order 6, Rule 2. Thereafter, we had also discussed about the object behind pleadings and have also discussed about verification and the amendment of pleadings as such. Now, in today's lecture, we are going to discuss about the plaint. The word plaint has not been defined under the Code of Civil Procedure. As you all are aware that various expressions used in the Code of Civil Procedure have been defined under Section 2 of the Code of Civil Procedure. But this particular word has not been defined by the legislature while enacting this law. So we may define it as a statement of claim or a document by the presentation of which the suit is instituted. So from this, we may say that it is a document by which a suit is instituted in a court of law. Furthermore, I would like to explain that the word civil suit has also not been defined in the Code of Civil Procedure. But the suit is instituted only by way of presentation of plaint. This has been laid down under Section 26 of Code of Civil Procedure, read with Order 4, Rule 1, CPC, 1908. Furthermore, the plaint can be defined also as a pleading of plaintiff. Furthermore, as I had already apprised you that pleadings includes two expression, that is plaint and written statement, as these two are one of the most important elements by which the court may draw or frame issues in a civil suit, meaning thereby these documents will provide or give an insight about the dispute in issue between the parties and helps the judge to know about what is the problem between the parties to the civil suit. Now, I would like to explain to you the relevant provisions given under Order 7 CPC pertaining to plaint. Some of the most relevant provisions are Rule 1 to 8 of Order 7 relates to the particular of a plaint. Rule 9 lays down the procedure on the plaint being admitted. Rule 10 provides for return of the plaint. Rule 11 to 13 deals with the rejection of plaint, and Rule 14 to 18 deals with the or contains provisions relating to production of documents. So, regarding the structure of the plaint, we have to bear in our mind the rules pertaining to Rule 1 to 8 of Order 7, and thereafter the procedure to be taken into consideration by the court while admitting, return or rejecting the plaint. And in the end, we may discuss about the provisions relating to the production of the documents, meaning thereby it is the duty of the plaintiff to produce all his documents which are in his possession and to produce the same before the court of law, and thereby satisfy the conditions laid down under Section 63 to Section 65 of Indian Evidence Act. Hence, we may read the interplay between the provisions of Indian Evidence Act with that of Code of Civil Procedure 1908. Now, I would like to move further. Here, I would like to point out about the particulars needs to be mentioned by the plaintiff or by his counsel while drafting a plaint, meaning thereby the points to be considered while drafting a plaint by the counsel of the plaintiff. First point that needs to be mentioned in the plaint is name of the court in which the suit is brought, meaning thereby the jurisdiction of the court has to be mentioned, because as you all are aware that if the court in which the civil suit has been instituted and that court is not having the jurisdiction, then the decree passed by the court, by the said court, it may tantamount to nullity in the eye of law. So, it is very much relevant to mention the correct name and designation of the judge or the presiding officer, as the case may be, needs to be mentioned in the plaint itself. Second, name, description, and the place of residence of the plaintiff and defendant. What is the need of it? The need of it is that the court must know the where the parties are residing and what is their name, so that there cannot be any anomaly between the documents of one particular case with that of another case, meaning thereby it distinguishes one case from another, and it also helps the court to call the party in case the party is evading from appearing before the said court, and the court can send summons to call them by way of registered post. And as you all are aware, that the registered post can only be served if there is proper address to that effect. Next, where the plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. What is the need of it? The need of it is to apprise the court about the condition of a person, or to tell the court about the competency of a person to enter into a contract, meaning thereby, as you all are aware, that section 11 of Indian Contract Act deals with the competency of a person, and minors contract is void ab initio, that is nullity in the eye of law. As such, to give a protection to the major person or the other party to the case or the plaintiff to the case, then in that case the minor needs protection as well. So the court the court has empowered the minor to get himself represented through the guardian or the next friend, as the case may be, before the court of law, and the relevant provisions regarding the same has been given under Order 33 of the CPC. Next, the facts constituting the cause of action and when it arose, the need of it is to apprise the court about that the case has the cause of action, and it helps and the court to know about that the limitation period still exists in favor of the plaintiff, meaning thereby it extends the time period for filing a civil suit in a court of law. Next, the facts showing that the court has jurisdiction. This also relates to point number one, and meaning thereby it is the duty of the plaintiff to apprise the court how he has come to the conclusion that this particular court before whom he has filed this case has the jurisdiction to try the civil suit filed by the lawyer or by the plaintiff's counsel on behalf of the plaintiff. Next, a statement of the value of the subject matter of the suit for the purpose of jurisdiction and court fees. In this, it is the duty of the plaintiff to mention about the court fees also and also about the statement of value of the subject matter of the suit for the purpose of jurisdiction. And in the end, it is a duty of the plaintiff to mention about the relief claimed by him on the basis of the cause of action against the defendant, where the plaintiff files a suit in a representative capacity. The facts showing that the plaintiff has an actual existing interest in the subject matter and that he has taken steps that may be necessary to enable him to file such a suit. Next, where the suit is for recovery of money, the precise amount needs to be claimed. Next, where the plaintiff has allowed a set off or relinquished a portion of his claim, the amount so allowed or relinquished. Next, where the suit is time barred, the ground upon which the exemption from the law of limitation is claimed, meaning thereby he has to mention the facts whereby he seeks condonation of delay in filing the civil suit, and the conditions for the same is that they have to or the plaintiff has to show before the court about the and he has to give the sufficient reasons with regard to condonation of delay. Now, I would like to move further. At this point of time, I would like to mention that some of the paras in the plaint are mandatory in nature, and these are the parties to the suit, meaning thereby who are the parties to the suit. Second point, cause of action. In this, the plaintiff's duty is to disclose that on what course of action he has filed the case in the court of law. Next, he has to apprise the court about the jurisdiction of the court. Also, how he has come to the certain value and how he has calculated that particular value for filing a case before a court of law. Next, he has to apprise also about the limitation and also the relief claim in a civil suit. Next, this is very important not only for the understanding of a law student but also as a lawyer as well, because this is one of the provision which ends the suit at its threshold, meaning thereby the plaint can be rejected on the following grounds, and these grounds are given under Order 7 Rule 11 CPC. The grounds on which the plaint can be rejected are as under. Number one, where the plaint does not disclose a cause of action. As you all are aware that it is the mandatory paragraph to be mentioned in the plaint that a cause of action exists in favor of the plaintiff. In case the cause of action does not subsist then in that particular circumstance, the suit may be dismissed. Furthermore, at this particular point of time, I would like to mention that cause of action has to be seen only on the basis of the plaint and the documents filed by the plaintiff. The averments made by the defendant in his written statement and the documents filed by him have not to be looked into. This was so held in the important case of Kailash versus Nanku, AIR 2005 Supreme Court, and there are many more judgments on this point. Next point is where the relief claimed is undervalued. In case by bona fidely the plaintiff committed a bona fide mistake whereby he has valued his suit undervalued, then in that particular circumstance, before rejecting the plaint, it is the duty of the court to give him an opportunity to put the correct valuation and to put correct court fees in the meantime. And if he does so, the plaint would not get rejected. But if he does not do so within the time limit given by the court, then afterwards the court has also the discretion to reject his plaint under order 7 rule 11 CPC. Next, where the plaint is insufficiently stamped. This is related and the reasons which I have given in point number 2, the same may be reiterated and the same are not repeated herein for the sake of brevity. Next, where the suit is barred by law. If the suit is barred by any law, then also the plaint may be rejected by law by the court of law. Next point, where the plaint is not filed in duplicate. As you all are aware, this particular amendment was made in the year 2002 so as to, in case the defendant does not get the complete copy, then he may take it from the court, thereby to minimize the delay, and he will file the his WS within the time frame given by the court itself. Next, when there is non-compliance with the statutory provisions. If the statutory provisions have not been complied with, then also the suit may be rejected. The relevant provisions with regard to it, Order 7 Rule 9. Next point. What is the object behind production of document along with the plaint? The object underlying Rule 14 is to exclude the production of a document of a doubtful nature at a later stage. So this is all about today's lecture. Hope you all have enjoyed the same and also learn from it. In the meanwhile, I would like to apprise you about my new topic, which I am going to take in my next lecture. And the topic of my next lecture would be on written statement, which means the reply of the defendant. And the provisions pertaining to the written statement are given under Order 6, Order 8 of CPC 1908. Will meet you in my next lecture. Hope you have a great day ahead. Thank you very much. We'll meet you very soon. Thanks once again.